with respect to, does anybody have any conflict of interest or appearance of conflict of interest to report that may prevent you from participating? All right, hearing none, then we'll get started. A little bit of a background as far as this referral. Kim Speos, who's the new director of the Conference of District Attorneys, I talked to her earlier today, and she gave me some background why Jamie Adams kind of got this ball rolling. I think initially it was just an inquiry or some advice on how to handle. And basically what happened was she's in Scotland County as a prosecutor, and she had a group of people come from out of the county, from High Point, that area, and engage in some violent acts. They shot at some people who were in some cars, things of that nature. Most of those people that were charged obtained court-appointed counsel. Shortly thereafter, she started getting calls from lawyers who were not the court-appointed attorneys to talk about the case and to establish some sort of parameters for bond hearings and setting up bond hearings. And she basically told these attorneys who were not representing the defendants that, you know, she would be glad to discuss the bond with them once they made an appearance, whether it was a general appearance or a limited appearance in the matter. But until then, she really didn't have anything to say to anybody about the case or a bond. And I think she kind of got the feeling that some of the court-appointed attorneys were unaware that these other attorneys were making inquiries about bonds. And she said some of them got pretty heated with respect to her not willing to discuss the bond issues or if it then bled over into the actual substantive issues within the prosecution of the matter. And so she basically felt like this was something that's becoming more prevalent. And it is something that happens. You know, I think in our job, I didn't coin this phrase, but we call them bond pirates. You know, with the water around us, where they come in and they'll swoop in and they'll take money from a family member or the defendant themselves and just represent them on the limited basis of a bond, but not actually get in the case. And different Superior Court judges have different perspectives on this. A lot of them dislike that reality or won't proceed with either counsel that has been appointed present or that person or that attorney making an appearance, a general appearance. Generally, if they're limiting their appearance, as the case may be. And of course, the other issue, and I think this is of a concern to a lot of the public defenders and court-appointed attorneys, is the reality that sometimes they don't even know it. Sometimes they're unaware that their client or their client's family has hired this other attorney until either they get a call, oh, here's a bond hearing, or they find out after the fact that that there was a bond hearing. So I think that's kind of what precipitated this inquiry and the establishment of the subcommittee to discuss. Any questions about that before I'm going to turn it over to Nicole and let her kind of talk about the opinion, the proposed opinion, as the case would be, in the other issues that we have to deal with. Okay, go ahead, Nicole.
Okay, so this is an inquiry that we got from Lawyer Adams regarding defendants who are appointed or are qualified as indigent and then are appointed counsel, and then subsequently either the defendant or the family of a defendant retains a lawyer to represent the defendant on a limited basis just to handle the bond hearing. So in the first inquiry, the question is whether or not the lawyer can communicate with the defendant based on new representation, knowing that there has been appointed counsel. And the answer is yes, because under Rule 4.2, which is what we call the no contact rule, but that's the rule that says that a lawyer who wishes to communicate with a person or entity that is represented by counsel in the matter for which they want to communicate must get consent of their counsel if they know that the person or entity is represented by counsel. There is an exception in the rule that says that if a lawyer where a person is reaching out to the lawyer for a second opinion or for new representation, then that lawyer does not need to get the prior lawyer's consent. So therefore, the answer is yes, the lawyer can communicate with the defendant, even though the defendant has been appointed counsel. The opinion also says that the lawyer should, but is not required to inform appointed counsel of his participation and advice to the defendant. In the second inquiry, the question is whether or not the lawyer may limit its representation. The opinion references Rule 1.2, which is under the rules, you can limit your representation of a client by agreement, provided that the limitation is reasonable under the circumstances and the client gives informed consent. So that's basically what the ethics opinion provides. In opinion number 2, there's a little bit more analysis about Rule 1.1 on competence, Rule 1.4 on communication. And as long as the client understands that there may that the lawyer's limited representation may have an adverse impact or some kind of impact on the client's ability to maintain indigent status and to keep their appointed counsel. So the rule or the opinion requires that the newly retained lawyer have a conversation with the client to make sure that the client understands that and gets the client's informed consent to proceed, knowing that they may lose their appointed counsel for the remainder of the criminal matter.
Okay. Thank you, Nicole. Anybody want to talk about anything in particular as to each of the questions, each of the inquiries and the opinions flowing therefrom from Nicole? I've got a couple of things I want to talk about, but I wanted to kind of open it up at this point in time.
I mean, they're glaring, they're glaring things there. I mean, I certainly agree, and it's been longstanding that defendants can seek a second opinion, but there's a concern for the representation, in my opinion, for the defendant, for someone to come in and represent them and not understand the full extent of the case against the defendant and come into court, make certain claims, representations, bring in witnesses, for purposes of a detention hearing, not realizing that may negatively impact the defendant's case because they're not fully aware of all the facts against them at that time. So that's a first concern, besides the fact that it may impact the indigent status. That is one of my concerns. The lack of coordination is concerning for me, for the defendant. And it also, if I were the attorney, the assigned attorney, it would bother me as well to have another attorney intervene and not know what was said and not, come in secondhand. So, but I also have seen cases, probably as all of you have, where an attorney, the representing attorney, may be in trial and a person's been in jail or in custody for a while and really wants to be released and is impatient, and their family hires someone to help get them released. And, I understand that need as well. So where's the balance? I'm not sure.
Well, I kind of have a different view of it, especially, the part about someone coming in not knowing what's going on. To me, that seems more like competency. That seems like you're not doing what you're supposed to do, right? So maybe it's because I'm in a smaller district, the DA's office and the defense bar, we don't have any issues talking to each other. So I can't imagine, because people have hired me to do bond motions, but they generally retain me, you know, for full representation. So I just can't imagine somebody hiring me for a bond motion and I'm not talking to the DA, or I'm not trying to see the discovery or whatever. Like, that just seems to me more about the lawyer than necessarily the practice.
Okay.
So I'll just jump in here to share my thoughts. I'm not entirely sure how organized they are or where it goes, but you know, from my standpoint here at IDS, you know, we have different delivery systems throughout the state. In some districts, we have public defender offices, and appointed counsel may or may not come from the public defender offices. In most counties, 65 of the 100, we rely on private assigned counsel and a roster system, and we have limited ability to control the behavior of the attorneys on those rosters in many respects. They're supposed to be governed by their local indigent committee, and in any event, so it kind of, it troubles me a little bit that if somebody is appointed an attorney in one of the 65 counties, that attorney isn't getting in and asking for a bond hearing if it's appropriate, right? That's separate and apart from whether, I guess, it's ethical for the family to retain somebody else. It is, in other words, is the original court-appointed attorney doing everything they're supposed to be doing on behalf of their client? I know, and I wish Bert had joined us. I've talked to him a little bit about this, and in public defender counties, his perspective is they are so slammed and overworked, and I know this is true, their caseloads are crazy, that he welcomes any effort to sort of ease the burden on his attorneys. And if there's a family member who wants to try to hire somebody to come in and handle a bond hearing, that's one less thing his folks have to do, and they can concentrate on the, you know, the substantive representation. So that's kind of one area that concerns me. Another thing about this practice is, and I hear what Robin is saying, is this a reasonable limitation on representation? And if you're coming in for the bond hearing only, do you have are you able to, it seems to me a bond hearing is something that you could probably carve out and do relatively little harm to the case, right? If you do it skillfully. I had a call not too long ago from Judge Bridges in Cleveland County and the chief district court judge out there, and they were asking me about a practice that they have seen recently, which is where defendants will retain counsel solely for the purpose of entering a guilty plea. That's in the retainer agreement, right? And then if that guilty plea can't be worked out, the attorney withdraws, and oftentimes counsel is then appointed. And as one of the judges put it, how do you know that the nest hasn't been fouled at that point, right? I think that's a much more, that's not a reasonable limitation on representation, but that's not the question before us today. But I kind of wonder how we can get that question before. I suggested to the judges maybe they submit it because they've seen it. I think that is not a reasonable limit on representation. But anyhow, that's maybe something we could look at separately or in conjunction with this this examination. And then the final thing I want to say is that if somebody's family member scrapes up some money to retain somebody for a bond hearing, that's one thing. If the defendant has money to retain somebody for a bond hearing, his appointed counsel is supposed to bring it to the attention of the court, right? That, well, he's got some money, maybe we need to re-examine the indigent status here. And that's not happening if the appointed counsel doesn't know that this has happened, right? So I'm not sure where that's addressed either. So those are my thoughts.
Well, I think
how they relate to the problem before us, I don't know.
Well, I think if I'm not mistaken, Mary, thank you for that. Is some of those, unfortunately, I think some of those, and same with the concerns that Robin mentioned and that Takia brought her insight into, is that some of that's kind of covered within the rules to some degree. Yeah, I guess the gray area would be is it the defendant seeking a second opinion about his legal status, or is it somebody else seeking that second opinion for the defendant and kind of stepping in that situation? And I think I agree with Takia. In a small jurisdiction, it may be rare that defense attorney may not be able to know what's kind of going on if they're stepping in just for a bond. But I'm confident in larger jurisdictions that there is no communication between defense attorneys and DA's offices. And while we may have an open door policy for our defense bar, I know there are some jurisdictions that don't. And so everything's done by writing or by motions or pursuant to the local rules. So I think that's, kind of where we go in some respects. So understanding that's, I think, one reason why we need to kind of formulate these opinions in such a way, because one of the concerns I have, it's kind of looking at, when you look at the opinion, this idea of, again, you've mentioned it, how does it affect that person's indigency? Because I have some district court judges that take it very seriously. I have others that don't take it as serious when it comes to levels of indigency. And I've had some judges actually want to charge perjury of a person on their indigency affidavits. Where others just, kind of turn a blind eye at some point in time. So I think that is an issue. And so, and then really, how is this going to affect that defendant's case? I can foresee in a situation where a defendant may actually make statements during a bond hearing that are prejudicial to their criminal matter, where it actually helps the prosecution but hurts his or her defense in that sense, or statements from counsel may shed light on to potential defenses that maybe trial counsel didn't want to broadcast at that point in time from a strategy perspective. And that's why I'm trying to think, Nicole, Brian, you can chime in here. I don't see anything within the opinion as drafted that could be changed to cover these things we've talked about, maybe an emphasis on some of these things. But, it's kind of like everything we've talked about is kind of covered by the opinions that have been written the way but obviously that's just my opinion.
Yeah, that's correct. And we have to be careful about not putting something in the opinion that tells the judge what to do.
Yeah, and I think that's, it's kind of like we've had some judges locally that don't like bond pirates. They just don't do it. I've had others kind of say, okay, let's have your motion, but I'm not going to hear your bond motion without the actual appointed attorney present, with an understanding that, there's a potential jeopardy here to the defendant, depending on what's being said, to try to get the defendant out. If you're talking about an alibi defense, obviously some of the other defenses, some other dude did it, that's kind of typical. But if you're talking about an alibi defense, that may be shot to heck if, depending on what's said during a bond hearing. And I know from my limited experience with the public defenders is it may reduce their caseload, their workload, some sense, if somebody hires an out of a private counsel, but I don't think they should be in a situation where they're surprised by it, because it certainly it may put them in a bad position when it comes to actually representing the interest of the accused, as the case may be. I see Bert and John Webster both joined us. Bert, John, got anything to add?
I apologize for being late. I don't know what has been discussed before I got on. We have what Thomas described as bond pirates. And candidly, in my 20 years, it really hasn't been an issue. And we really don't mind it with regards to bonds. because the way that the system works is that sometimes we don't get the paperwork for 2 or 3 days administratively before we even have an opportunity to be able to get the paperwork, get the assignment, and go see the client. Well, sometimes the families are extremely impatient. They want to go ahead and hire an attorney just to handle the bond. And, that's fine with us because at least that's helping out the family. It's much better than the family contacting our office and jumping up and down and not understanding why we should have to drop everything that we do. I mean, so essentially what they're paying for is convenience of time for an attorney. Now, the issue, our meaning in the public defender, and I can only speak from my foxhole, is these attorneys that will come in and they will limit their appearance in felonies in probable cause court, and then we're out of the case, and then all of a sudden they jump out, and then we're back in there in the case in Superior Court. We've lost 2 or 3 months time and maybe even 6 months time. And we're stuck with this case, and the judge is saying, okay, all right, you plead guilty or not guilty. And then before you know it, in 60 days, we're on a trial calendar. Now, of all the issues, that drives us nuts. And typically we have, flushed out the particular attorneys that do it. There's not very many attorneys that do it now, but that's probably because we have, I don't want to say the word shamed them, but I mean, we've really talked to them and saying, look, you just can't do that. I mean, it's just wrong. It's just unprofessional about that. Or the folks who are getting some money for like a continuance. Now that's just outright wrong when we can be able to do that. So, but I understand they have their right to an attorney. And so will it ultimately be, if everything falls through, our case at the very end, which typically it is. And Tom knows this better than everybody. And I'm sure Mary knows this as well. Robin, maybe not so much because they don't allow this in federal court, I'm sure. And I'm only guessing, Robin, I am not by no means. It scares me just to go into that courthouse. But we always get fired at the eve of trial. Always get fired at the eve of trial. There's a motion. And then sometimes there are attorneys coming in, especially in these murder cases, where the family has gained $30,000, $40,000, $50,000, plumped it in someone's lap, and then they're trying a case with 72, maybe 96 hours preparation, and they're going in there in a murder case. And those are the things that really raise my eyebrows. And I know I'm maybe digressing from the original subject, but I doubt that any federal judge would allow that. But sometimes and maybe they do, Robin. And so I am very much in pleading ignorance when it comes to that. But sometimes the judges will allow us out. They're like, okay, well, you got 40 grand if it's okay with the client. I mean, they don't talk about the price, but it's like, well, if you're fully retained and you got fully retained this weekend, we're not going to move the case any further. We're going to pick a jury. But of course, in the back of their mind are they building in an IAC claim? So, that's always a concern as well. So again, I apologize for being late.
Thanks, Bert. I think listening to everybody's concern, and I don't, John, John Webster, I know you're listening on the phone. Do you have anything to add? He's still muted, so I'll wait to see if he gets on. There he goes. There he goes. There you go. Thank you, John. Yes, I can hear. We can hear you now.
Got two things technically challenged. I would just follow up on what Bert says. I'm a private practitioner, and in this situation where a lot of the things that everybody has already said sort of happen here on a regular basis. And this is sort of the scenario that I see continuing to be a problem. And maybe it's not a rule issue. Maybe it is more of a court-appointed counsel issue, or how the judges apply those rules. But what happens here, and there are a handful of private attorneys that will do this, we'll get appointed We'll go up to court. I've got 2 or 3 right now that are in this situation. We'll go up to court. We'll start the process. We'll file the motions for discovery. We'll meet with the client. We'll do all that stuff. And then somewhere down the road, they get upset because their case is not getting handled as quickly as they want it to get handled. So they go and talk to private lawyer. Private lawyer comes up, and sometimes it's a bond motion. Sometimes it's a limited appearance for a continuance. Sometimes it's, I don't even know. So most of the time it turns out to be some type of a limited appearance. And typically here, like Kia said, this is a small district as well. This is not where we see a lot of the people getting hired just for bond reductions. It's usually to make a limited appearance in the case that starts with a bond reduction motion. And then they're in the case up to and including the entry of a plea potentially. They basically come in, take the person's money, and essentially if they don't get what they want with the plea, we're still sitting there dangling. And here's what the judges say to us. They say, your court-appointed counsel, this person is making a limited appearance for whatever the reason is. I'm not letting you out of the case until they come in and make a full-scale appearance for the client. And we're stuck with basically, like Bert said, on the eve of trial, we either get fired or not. But those people basically take and run with the case and make the money and run through all this person's funds. But the judges never address the issue of us being court appointed, whether or not the indigent status really changed or matters. But beyond that, to me, there's an ethical consideration for the court appointed lawyer. What are we supposed to be doing when they have our client has represented to us that they're hiring a lawyer, whether they've fully done that or not? We are not being contacted anymore by mom or dad that are concerned about little Johnny or little Johnny himself. They've run off and gone to this other lawyer's office, and they're communicating only with them. They're not communicating with us, but we're still in the case. And I've had it happen where at the end of the day, we find out that we're put on next month's trial calendar, and they just, we just didn't have the money to hire lawyer X, so you're stuck trying the case. And so from an ethical perspective, I see this as a dangerous thing. What I really would love is a bright line rule that says either make an appearance or don't make an appearance. I know that's not going to happen, but that's, sort of where we get stuck, and it regularly happens, and I'm not the only one that has that opinion. I don't know how you address that other than maybe the judges need to be educated to ask these questions on their own. When somebody walks in there and represents that they're hiring a lawyer, I don't care what the capacity is, to me, they're not indigent anymore. I don't care where the money comes from. We never ask that question as private lawyers, who's bringing the money. It's from our client. And so, I hate getting stuck in that position. And I don't know if this is the right forum to handle that question or not, but that's where I see this continuing to be a problem. It starts with the bond reduction motion and it moves up from there, and then we get stuck. And then the client, maybe they don't want us to represent them, but they're stuck with us as their lawyer at the end of the day, because we've sort of been left dangling. They call us standby or backup counsel. I don't even know what that means, but that's the way we get treated, and they won't let us out of the case. And I think it's because, generally speaking, they don't want the person to be without a lawyer if a trial falls on them, if everything else falls apart. So maybe that's another question, but that's an ethical consideration from the lawyer's perspective, from the court-appointed lawyer's perspective. What are we supposed to be doing? I mean, technically, we still represent them. Do we have to get prepared just like we always would without the client's assistance while this other lawyer is in this limited role, whatever the limited role is? Anyway, that's what happens here. Not sure if that's helpful or not, but
John.
yes.
Oh, okay. You have absolutely blown my mind in Pitt County. Now, I'm not saying that's a very hard thing to do, but we see it. There's really 2 instances where we see limited appearances. 3 instances. One, the first 7 days of someone getting picked up. 2, limited appearance for purposes of district court only, like maybe a DWI and sometimes felonies. Those are the ones that drive me nuts. 3, limited appearance for continuance, but that's when we're not involved in it at all. And once in a while, we'll have a limited appearance for bond up in Superior Court, once in a while. But what you're describing about the limited appearance for purposes of a plea and everything else in between, I never knew such thing existed. So I'm really speaking from an angle of ignorance. I could not imagine one of our judges allowing that to happen up in Superior Court. So for what it's worth, I had no idea, none.
Yeah. It happens, and it happens regularly. And the backdrop to it is the court-appointed client will come to you and say at the last minute when they start getting worried about the case being completed, do you think if I hire somebody, I'll get a better deal? Or do you think if I hire somebody, I can get this trial continued? Do you think this? Do you think that? And I basically say, look, if that's what you think you need to do, then you need to do it. I'm not going to perpetuate whatever it is you're thinking you need to do. You need to make that decision. But the backside of that is when the lawyer comes in there and says, I'm making a limited appearance to move to continue this trial date. My client's working on hiring me. We need some time. And I look at him and I say, Judge, I'm making a motion to withdraw. If this person's representing to you, they have the money to hire somebody. I need to be out of this. I don't need to be dangling on a thread. And we're routinely met with, I'm going to leave you in the case as the court-appointed lawyer, but Mr. So-and-so, you have until December 15th to get your lawyer retained and report back to the court whether you did or not. In the meantime, you're getting put on the trial calendar in January, and they look at me and say, you're going to be basically standby counsel for now until we get a final answer. And that's, to me, is ridiculous, but that's
I agree. I mean, now that does happen for admin court for us. Administrative court up in Superior Court, Your Honor, we just like to continue it another day to see, or the next month. But once it's in trial, for us, for our little foxhole, nothing like that would ever happen. The person's either in it or they're not. But anyway,
that's the way it should be.
Yeah, I agree with Bert. It's like that where we are. There is no, you can't get out of it. That doesn't happen. So it seems almost like a judge issue in your district, especially because I will tell people all the time, they'll come, well, how much does this cost? I want to hire you. And I'm like, well, what posture are you in? Because if you don't give me money and I'm stuck in it, I'm gonna be mad, so so it just almost seems like it's a judge issue, because I think it's on the judge to either let you withdraw or keep them in it. You can't have it both ways. And it's just crazy that they're doing that. Like you can't have it both ways.
Kaya, I appreciate that. I agree with you guys wholeheartedly. And if we can agree that it is a judge issue, I think that we probably need to then focus on what we're supposed to be focusing on. And I guess, and I'm going to ask this to Nicole and to Brian is, you've heard what the concerns are here. Reading the opinions, when I'm reading the opinions, as we were talking, what I was doing, I was kind of like highlighting the language and putting it in bold and italics, where the things that were really of focus for us were, the lawyer must consider whether the limited representation is reasonable under the circumstances, the effect on the ability to pay, even if a defendant remains indigent, despite having retained the lawyer has a duty to review the law and render objective, candid, and thorough advice for the defendant regarding this issue, the issue they're being limited their appearance to. I think it's also important that, and this is going to be a judge issue, but I think whether we're on the prosecution side or the defense side, can say, okay, judge, the defendant has to consent. Maybe that requires, the voluntary, informed, knowledgeable consent that the court would have to engage in to make sure that defendant understands the circumstances and the consequences of allowing this limited representation of his or her interest for the purposes, whatever the limited interest or limited representation is for. And that they should also inform the appointed counsel of their involvement. And I don't know if there's a way we can kind of refocus some of that language. I don't know if it's kind of like bullet points, something that maybe somebody reading this opinion would be able to go to it and say, well, if I'm going to get in on this on a limited basis, these are the things on a limited representation for the purposes of a bond. These are the things that I need to do as that lawyer. Okay. And it allows us, whether it's Bert or the prosecutors, to say and look at it. And when that attorney wants to come and have that bond hearing through a limited representation, have you done blah, 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 1, 2, 3, 4, 5, so to speak. And that way, when it gets in front of a judge, and again, this is some of a judge issue. I think, it'd be a great idea if we could get some of the Superior Court judges kind of understand the headaches and the dynamics that are at play here when you have people like John who are on that court appointed list, or the public defender, and the impact that these things have upon their administrative, and for John, just whether or not they're even in the case, and what they have to do to prepare for trial, or if they have to prepare for trial. I'm gonna stop there and kind of ask Brian and Nicole can we do that? Can you somehow fashion the opinion to focus in on those things that clearly us as a subcommittee have identified? And I think we got a great, diverse group here, from the defense bar to the prosecution to the public defenders. And Robin, with her experience, where she's been in this world doing her job. That's kind of what I'm thinking. I'll shut up now.
So I think we can include some examples. That's not necessarily an exhaustive list, because I don't think that, the opinion can go on for pages and pages and pages. Right. But if we give, some general examples, like talking to the DA, talking to appointed counsel, reviewing the discovery, is that what you're thinking?
That's kind of what I'm thinking, is just, so they kind of understand, we as the stakeholders in this process, both as the public defender or the court appointed, and then the prosecutor, are in a position to do these or be aware of these things. Then I think that may help them understand what their responsibilities are if they're going to be accepting this limited representation for whatever it is, whether it's just for district court or for it's a bond purpose. I'm not going to touch only for a plea, because I agree with Mary Pollard. I think that's outside the realm of representation or reasonable representation. But that's kind of what I'm thinking.
So, are you thinking like, because I'm thinking these rules were written mostly for generic, and I'm thinking more civil. We're trying to add a layer of, when you're doing engaging in criminal cases, and doing a limited appearance, have you done these things? Have you explained to a defendant who is already represented that what your limited appearance means, the possible jeopardy that it could cause, should it may, the impact it may have? Is that what you're thinking?
Yeah, and I think if Nicole uses it as an example, then the example is limited really just for that example, but it's not exclusive. It's not, this is not the purpose of this rule, but this is an example of how it comes into play, and its variables can be attributed to what that looks like going into court.
Yeah, because the rule requires that the limitation be reasonable. So, in the examples where you're giving that the lawyer is staying in, like in John's district in particular, where the lawyer is saying, I'm making a limited appearance, but then does a little bit more outside of what they initially said their limited appearances. So if they said, I'm here for the bond, but they don't withdraw after that, and they're starting to negotiate the plea with the DA, but then the client or the family runs out of money and the lawyer says, I'm out. then that's not reasonable under the circumstances to take a client, take on a client and try to represent them without expectation that you're going to complete the matter. Does that make sense? Like saying, I'm only going to represent you for as long as you can pay me. And that's not to say that lawyers should be working for free. I mean, that's not my point. But the point is, if you go into it knowing in the beginning that you're only going to stay in this as long as they can pay you, and then you're out.
And I know and I think we have to be cautious, because I think you could, you don't want to set the language as being the parameter of the example. So I think in some respects we have to be cautious if we're going to go down that path, and we may not need to. We may, and maybe we shouldn't. I don't know. Maybe we just kind of think about what language, what possibilities exist. If Nicole wants to kind of give us an idea of that in the future, kind of draft something. And it may be that, I mean, I've been on other subcommittees where it just got so big, that we had to contract and focus on the initial and stay focused on the initial issues and leave it at that, because you can nickel and dime yourself right into oblivion when it comes to these things.
Let Brian and me, like, I'll come up with some things and talk to Brian about it, and we'll see if we're going off a cliff here.
Yeah, I have to say, I think we have a good start, in this second opinion, where I feel like a lot of the stuff that's been discussed today is kind of touched on, as far as, Takia, to your point about just competency, that these lawyers, if they're going to step in, they need to be aware of that. I think we can beef that up and make it a little bit more obvious. I'm looking at opinion number 2, and just kind of saying that, essentially, lawyer, you need to be aware that your involvement could affect indigent status. And I know that was something that, when we were looking at this opinion originally and kind of going through some drafts, Nicole and I were talking about, I guess whether or not this disqualifies somebody is probably going to be dependent upon the district and how the judge deals with that. I don't know if there's a particular, and I don't know if anybody has an opinion here or a different perspective on whether or not an indigent defendant retaining private counsel will result in an automatic disqualification. Because if it's an automatic disqualification, to me, that's incredibly concerning. Whereas I'm hearing from other districts that it's not necessarily automatic. It's kind of, even in Pitt County, thinking like, well, hey, you retain somebody, private lawyer, for the bond hearing because we can't get to it. It actually works well in terms of divvying up the services that the client needs. And so we didn't want to draft it in a way that was just an absolute, but had enough flexibility to say, lawyer, you need to be aware of this, about the impact that your involvement is going to have on the client status, presuming that you've made that determination, you've advised your client as such. Now, here's where you need to step in. Yeah, you need to review the case. You need to render that candid, thorough advice. You've got a duty of competency, of communication. You have a duty to be an advisor. Discuss the limitations of the representation, the impact that has on the kind of the whole timeline of the representation. I think all of this stuff, we've touched on it in the opinion, and I think we can expand on that much more, because I think really what I'm hearing from everyone also is that this general notion, I guess maybe this is kind of almost the crux of the question, is it reasonable? Is it a reasonable limitation to step in purely for the bond? And it sounds like that's kind of it depends, that it could be. And if it's not an absolute no way, that's completely unreasonable, then I don't think we should write an opinion that says, just you can't do it. It's going to be, it depends. And if it depends, then that means it's permitted, provided that the lawyer has taken into consideration all the different kind of ripple effects of being involved, as well as is very aware of the professional responsibility that lawyer owes to the client. and kind of go from there. And I think, some of the examples of, things that you need to do, it's kind of almost like the opinion becomes not a prohibition, but a warning to other folks. If you want to do this, you need to, step all in. You can't do I love the term, the bond pirate. You can't just step in, swoop in, collect a fee, put forth minimal effort and disappear and potentially leave a client in a devastated position. You need to be that much more involved. And so how we put that out there, that's where I think there's a lot of shoulds, like the notion of lawyer who's stepping in for the limited representation, you should contact opposing counsel or appointed counsel, not opposing counsel, appointed counsel, and that you must inform the court that you're being involved. That's where we kind of drew that line. You must inform the court, but you should contact appointed counsel. Again, should being not necessarily that we could point to a rule that requires the lawyer to communicate to appointed counsel, but also recognizing that, I don't know what client is saying. Client might say, I just want you to get in the bond, do that, and be done with it. I don't want you to even talk to my appointed counsel. We couldn't really point to a rule, as ridiculous as that is. We couldn't point to a rule necessarily that says you must. So that's where kind of the thought process went here. And I think a lot of it sounds like it's dependent upon the judge, the district, circumstances of how things just evolve there. And so maybe we just need to kind of beef up and make more obvious some of the language that's already there.
Brian, this is Bert. What's wrong with, and I'm asking this, it's not a rhetorical question, but what's wrong with requiring must as to notice?
To the appointed counsel?
To the appointed counsel, or to the appointed counsel, because I think that is, now, even though we don't mind folks getting in the first 7 days, it would be really nice. I know the word's nice, but it would be really nice to know if they are getting into the for purposes of the bond, because sometimes we don't find out till we look at the shuck, or just like, oh, this is sort of magic. The bonds magically have gone down. So I think the notice thing, if there is a must, I think whatever we can do to strengthen that, I think that will go far. And I would say that notice is more than just putting a letter in the mail, because by the time that happens, then, they're already out of the representation. It needs to be an email or a telephone conversation or something. I mean, something reasonable in today's 21st technology world. So
I don't disagree with you, Bert. I think it would be lovely to have a must. I think the struggle that I have is, what rule can I cite that compels the attorney to inform appointed counsel? Other than just
have a rule, because
other than just deciding we think it's must. So that's the tough part. You could always, of course, I was thinking, well, isn't that prejudicial to the administration of justice if you don't tell somebody? Is that an 8.4D? Possibly, but again, 8.4D suddenly becomes this catch-all that I think ends up diluting the impact and the intent of 8.4D. So I'm not inclined to cite that. Although I think it's, again, I agree. I think notice to opposing counsel, or not opposing, I keep on saying opposing counsel, notice to the appointed counsel is as, if not more important than notice to the court, because that appointed counsel might step in and say, I know how this district operates. If you do this, I'm going to be done. You're disqualified. I know exactly what's going to happen. This is not in your best interest. And I need to inform my client that you're about to do something that's really, really bad.
I think that's what Robin was talking about earlier, about it being prejudicial.
Right.
Yeah. You're prejudicing the defendant in that sense. And we on this side of the bar don't want that to happen, because we're ministers of justice. And I work hard at making sure that it doesn't happen in any context. So, yeah, I agree. Okay, well, in light of that, Brian and Nicole, maybe we need to kind of wait. And after, I know we have council meeting coming up in October, so let's plan on maybe doing another meeting after that, maybe in November or something of that nature, or closer to, the final meeting of the year. Next year, excuse me, the first meeting of next year, as the case may be. Okay.
Yeah, that sounds good.
Is that okay with everybody?
Yeah.
Go ahead.
I was going to say, if I can just get kind of a general sense, is that the notion of kind of converting the should notify appointed counsel to a must? Does everybody on the subcommittee agree that if it's possible, it should be must?
Yes.
I would.
Yes.
I would
Yes.
like that.
Okay.
Yes.
I mean, I know that's something, like I said, I guess, Nicole, you and I, we don't have a rule off the top of our head that we can cite other than 8.4D. And I guess that's the general notion. If the ethics committee wants to take the position that it would be prejudicial in the administration of justice if in this limited capacity, retained counsel comes in without any notice to appointed counsel, that could be something that could be an interpretation that's at least offered, and maybe we could at least draft it and see how it looks on paper. Again, I just always have a hesitation of just kind of using 8.4D or citing 8.4D as kind of the spot where when you don't have a rule, you got that rule. But it very well may be appropriate here, again, because the administration of justice, we're talking about an indigent criminal defendant who may be doing something that frankly is irrevocable.
Brian, to put your mind at ease for us prosecutors and those defense attorneys, we always know that if we can't charge any particular crime, we can always charge obtaining property by a false pretense.
There we go.
We'll make it fit. We'll make it fit somehow.
Well, I mean, even in Marcy's law, Tom, I mean, it seems like every time I turn around, you're having to give more notice to the victim, almost to the point that they're becoming your client to a certain extent. And
right.
And Brian, I would also suggest, and this is my first time on the subcommittee, so if this is not warranted, then just please ignore. But I would maybe pick one or two Superior Court judges that you think a lot of when it comes to specifics in different parts of the state, and sort of give them their idea, because they may have a perspective that we're just completely missing that they've been following. Or maybe someone from the School of Government who's been teaching them on this. So just a thought.
I think that's a great idea, Bert. I think we'll pick you up on that.
And I'll give you one, Judge Irvin. I think, Judge Irvin is extremely scholastic when it comes to stuff like that. So.
That's great. Thank you. It's a great thought. I know we have some district court judges on the ethics committee.
Yeah, absolutely. Yeah, I'm not taking anything away from district court, but.
Right, but yeah, I don't think we have any. I think it'd be good to involve Superior Court and District Court. This is happening all over. So, great. Thank you, Bert.
Okay. Anything else to come before the subcommittee this afternoon? We're coming up on an hour. So, all right. If not, thank you guys. Appreciate everybody showing up and participating. Good discussion. Nicole, I'm gonna put it in your ball court now. Look forward to hearing from you.
Okay, I'll draft something and get it out to you.
Thanks all.
Thank you, guys. We'll
Thanks,
see you all.
everyone.
Take care.
Thank you, everybody.